Good afternoon, everyone. I think we're going to get started. I'm Matt Rojansky, for those who don't know me, director of the Kennan Institute, and I'm usually the only person who leads the Kennan Institute on the stage, but now I get to share the stage with Will Pomeranz, our intrepid deputy director, and I have to say this is just an awesome privilege to be able to launch his long-awaited book on a topic that I know is near and dear to Will's heart, but also to that of many of us who have spent years working in and with Russia and dealing with the vagaries of the Russian legal system as it is today, wondering, reading, and speculating about what it once was and where it has come from and where it may be heading. And I think we're going to cover all of those dimensions of the conversation today as we launch. I'll hold up the stage copy, Law in the Russian State, Russia's Legal Evolution from Peter the Great to Vladimir Putin, which I would note is also for sale out in the corridor, as long as we have copies left. So the book is available for purchase at a special price outdoors, and we also, once you've picked up your copy and gotten it signed by the author, we'll be very pleased to host you at a reception after this conversation. So we'll go about an hour with the conversation, and then we'll move into the dining room for the reception. How to introduce someone who, in these hallowed halls, needs no introduction? Stick to the facts. Will Pomeranz is, of course, deputy director here at the Kennan Institute. He's taught Russian law at a series at Georgetown University, and is, of course, both a PhD in Russian history and a JD. That's from the University of London and American University, respectively, and his bachelor's degree is from the University of Edinburgh. He practiced international law both here in the United States and in Russia, dealing with both matters of public international law, anti-money laundering, et cetera, and also FCPA, as well as private law, private international law issues. So he's extremely well versed as a practitioner of international law, and then, of course, as a scholar of Russian legal history, constitutionalism, Russian commercial law, et cetera. And his prior to this, his first book, his articles have been very widely published. Will has even coached me through my own publication of peer-reviewed academic articles, and I have to say he's not only a phenomenal director, he's also a wonderful teacher. So I share that with Will's students, who I'm certain are in the auditorium today. And last but not least, especially in recent years, I think you're one of the more famous voices on Russia on television. That's definitely the case in Canada.
Yes, yes. I'm looking forward to a big visit to Toronto.
NPR,
yes.
Absolutely. A huge fan club.
Yes.
So without further ado, I think what we're going to do is just have a conversation about the book. Mm-hmm. Try not to steal its thunder. But let me begin, if I can, with a quote that jumped out at me. From Peter the Great. I'm sure many of you have seen this before. Lawyers, what's the use of so many? I have only 2 in my whole empire, and I mean to hang one of them as soon as I return. So,
yes.
I guess my plea to you, Will, and to those of you in the audience, please don't hang either of us, no matter what you think of the conversation. Let's just start with this. So, the state is in the title of the book, Will.
Yes.
Why?
Well, because the state is the crucial actor. And what I've discovered through my research on the history of Russian law is that you can't understand the evolution of law unless you understand the centrality of the role of the state. The state is more than just sort of the administrative body or bureaucratic institutions that govern Russia. The state also is the institution that embodies the unity of the Russian Federation. And unity is, in fact, a crucial part of understanding the evolution of Russian law. Because if you look at the 300 plus years that I discussed in the book, you will find that virtually every major piece of legislation, national legislation, and the constitutions that emerged in the 20th century, they all start with this notion of unity. And what I discovered when I looked at kind of the philosophers of the late 19th, early 20th century was that the unified state meant not that the state was monolithic, not that there was one law, but that there was always only one sovereign. And that as different regions were incorporated into the Russian Empire, they acknowledged the one emperor, the sovereign, but in the process were also able to keep their own legal systems and notions of legality. And so that when you look at the Russian Empire up until 1917, you have a broad state that represents the common good. You have a system of laws, but you don't have an overarching system of law. And so you have individual pockets of either custom, individual pockets of foreign law within the Russian Federation, and it's all possible because of the broad notion of the state.
Now, you're touching on this concept that's featured prominently in the book of legal pluralism, and I want to get to that in a moment, in particular bringing it forward from the origins of law in Russia to today, when arguably there is legal pluralism. But first, you described the importance of unity and of one sovereign as if that's something unique to Russian law, and I guess what many of us who are students of European history would say, well, of course, divine right monarchies, one sovereign, right? This is not exclusively a Russian phenomenon, but what is it that's different about this notion of the state that Russians routinely reflect, whatever their system of government, in their law, versus the way that Western Europeans, for example, or Americans think of the state?
Well, you're right in the sense that the notion of state and law is common throughout Europe. And it has evolved in different ways in different parts of the European space. What is distinctive about Russian state and Russian state law is what essentially starts from Peter the Great onwards, and that Peter promotes the notion of public law, of an administrative state, without emphasizing notions of private law, i.e. notions of contract, of civil law, so that Russia doesn't have a single civil law system up until really the Soviet period. So what makes the state unique is that it focuses on the administrative, bureaucratic side of the state, but isn't balanced by a system of private law. And if you look at notions in France, in Europe, the notion of private law and the relationship and the interaction between the two is what defines, broadly speaking, the development of civil society in Western Europe. And so what's unique about the Russian state is its centrality, is the absence of a system of private law to balance the public law notions of the state. And the fact that if you walk into any Moscow bookstore today, and you take a look at these books on sale, you will start with the books on state and law. So it is the continuous idea that the law is subordinate to the state that makes Russia unique, and Russia doesn't have, as a result, notions of separation of powers, and it doesn't have what civil law systems acquire in the middle of the 20th century, and that is an emphasis on human rights.
Okay, so the Russian state is clearly a unique entity in law and probably also in practice, and yet we do have a private sphere of Russian life. We have a commercial sphere of Russian life. So legal pluralism is critical for Russia to work in reality. Take us through how we go from the adoption of little bits and pieces of law from other places under Peter to today's version of legal pluralism.
The term I will use is not to say legal pluralism, but this notion of duality of law. And that is a concept that has been expanded upon by Professor Catherine Henley, and it applies to notions in the late Tsarist period, and it applies to the notion of today. And what it emphasizes is what is unique about notions of Russian law and this notion of duality is that you have a very compartmentalized vision of law, where you have a private law sector, whether it be today in terms of the commercial courts, the civil code, kind of lower level courts such as the justice of the peace courts that deal with small claims, etc., where you have a system of law that the state essentially allows to be independent, that the state doesn't directly interfere. There are, of course, examples where the state has interfered in notions of private law. I'm not going to pretend that it is absolutely independent, but it has a strong streak of independence. And you can identify that today, and you can really identify it in the end of the Tsarist period. Again, where you have a digest on civil law, where you have commercial courts, where you have private property rights, and where you have, again, a system of private law that essentially is acting independently. But what is distinctive about the Russian approach, again, is that this system of private law, which is very imperfect in many ways, it doesn't impinge on the public law powers of the state. And the public law powers include notions of administration, criminal law, constitutional law. In that sense, the state is always endowed with a notion of state power that is not limited by law.
So on that, tell us about nadzor.
So nadzor is a critical part of the Russian legal system because since it is so highly bureaucratic, since it doesn't have a means for most of Russian history whereby law is put forward by the legislature, the autocrat or the Communist Party official is always concerned about the independence of the law. And so Russia has developed this system called nadzor, or supervision, and it has been led for the better part of 300 years by the prosecutor's office, the procracy. And the procracy's powers of supervision have ebbed and flowed over those 300 years. But it has been primarily assigned the responsibility to monitor and to supervise the state administration. And it was founded by Peter the Great because he wanted someone to watch over the ruling Senate. He wanted to be informed as to what it was up to and what sort of rules and legislation it was passing. It reached its height in the Tsarist period under Catherine the Great, where the prosecutor general was essentially considered a prime minister. It shrunk during the last century of Tsarist rule, but returned in a very extreme form under the Soviet period, where they were granted broad powers of supervision, again, not just of judicial institutions, not just of criminal investigations, but also essentially over the entire state administration, so that it could kind of delve into the level of the collective farm or the factory. And so the state has always relied on this notion of nadzor, of supervision, to ensure that its orders are observed, fulfilled, and are transferred to the regions. So nadzor is a critical part of the Russian legal system because it provides the state the ability to supervise and oversee the implementation of Russian law.
Now, it's often the case that if you're looking to understand law, in particular in a civil law country, you go to the code, you go to the documents, and not necessarily to what a court says or what a commentator might say. In Russia, what is that documentary body? What do you look to understand Russian law?
Well, you look at different codes, yes, but so in the Tsarist period, you have the Uложение of 1649, and then no code appears until Nicholas I, in terms of until 1832.
So
and
no new written law.
Well, there's plenty of law. There are plenty of decrees. There are plenty of different pieces of legislation, but there's no overarching notion of a civil code or codes that supplement the original law code of 1649. Nicholas I creates a digest of laws first he collects all of Russian laws, and then he kind of focuses them into a digest. And a digest is really a compilation of laws. It really doesn't rise to the level of code, except for the Digest on Civil Law, which in fact is a very sneaky document composed by Count Speransky, where he somehow finds a way to take French and Austrian legal principles and stick them into Russian law, and then decides that since they're in Russian law, you can put them in the digest of law. And so Russia has this digest of law. It has commercial law, and that it's imperfect, but that's what Russians look to during the Tsarist period, with important caveats. One, the peasant population after 1864 is really not governed by these codes. It's governed by custom. And the second caveat for the Tsarist period is that in the western part of the empire, in Poland, in the Baltic states, and in Finland, they do not adopt the digest of Russian law. They continue to rely on, in Poland's case, the Napoleonic Code, in Finland's case, the Swedish Code, and in Baltic case, German civil law. So that you have this, again, the pluralism that I was talking about, that there's not one overarching system of law, but it is, it depends on the region, and it depends on the nationality. And what you have essentially is this, what is described as a differentiated system of law and rights, depending on your nationality, where you live, your occupation, and so forth. The Soviet system does begin to introduce codes. The fascinating thing about the Soviet system and its law codes is that in the 1950s, they passed these kind of supranational codes, which are essentially templates that the regions adapt as their own codes. So there's a Ukrainian civil code, there's a Ukrainian code of criminal code, et cetera, et cetera. And the assumption is that all these codes are derivative and have no independent value whatsoever until the end of the 1980s, when lo and behold, these codes come to life and play a critical role in undermining the supremacy of the Soviet Union, because the regions have been endowed not only with their own legal institutions and not only with their own constitution, but also with their own codes. And so these codes, again, play a critical role in where Russians turn to find the law. I can go into more detail, but maybe I think that's a good place to
So you've already touched
stop.
on this, the C word, constitution. I don't know what you people were thinking.
Mm-hmm.
There's the famous story of the Decembrist uprising, the calls for Konstantin I Konstitucja,
Mm-hmm.
and the soldiers thinking that Konstitucja was the wife of Constantine.
Mm-hmm.
When do Russians en masse begin to live, at least nominally, under a constitution? And what does that mean for Russia?
Well, one can argue that the digest of laws serves as a constitution. One can argue that even under Alexander I, there's elements of a constitution, because he invents the state council that in theory has to review laws and that laws have to be generated from the state council. But it doesn't really have that any teeth, and it's easy to be avoided. The first genuine constitution is the fundamental laws of 1906. And what I always like to highlight is the first clause of the 1906 Constitution, because it also leads with the notion of the state. And this first clause is the state is one and indivisible.
Mm-hmm.
And again, focusing on the notion of unity. The first time Russia had a chance to articulate what was its highest value, it focused on the notion of state integrity and unity. And then, of course, Article 2, it says that Finland has its own separate set of laws and regulations that are distinct from the Russian Empire, thereby casting into doubt what actually Article 1 means. And it goes on from there. But there's obviously long debate about the viability of the fundamental laws. It's only really in practice for up until 1914 because the Duma is suspended. But it does have some evolutionary promise, and it does implement, for the first time in Russian history, a defined hierarchy of laws, where laws by the Duma outweigh decrees by the Tsar. Now, the Tsar finds ways around that, and it's very complicated, but that's really kind of the first constitution. Then there are all the Soviet constitutions, and there are 4 of them.
The most democratic constitutions in the world.
Absolutely, and I spend a lot of time discussing the Soviet constitutions, recognizing that in many ways they are a facade and not real. But they are a very good way to approach certain fundamental issues and understandings of Soviet law. For example, notions of rights, how they perceive rights, how they notions of federalism are very important. It's very important to understand the constitutions to do that. Notions of state power, the judiciary, all these things, and sources of law. All these things are discussed in Soviet constitutions.
Role of the party.
Well, only the only the 36th Constitution and the 77 Constitution actually mention the roles of the party. And the party goes from Article 126 in the 1936 Constitution to Article 6 in the 1977 Constitution, reflecting the development of socialism and how far it has advanced. But you know, the Constitution itself is in many ways a facade. The crucial thing is the party, and we learn again through the Gorbachev reforms that when Gorbachev decides to abandon the party in 1990 and somehow try to rule through state institutions that are described in the Constitution, it doesn't really have any positive impact. And he quickly realizes that these institutions don't work. Because how could they work? They were always held together by the party. If Gorbachev can't rely on the party, these institutions just fall apart. And then you have the 1993 Constitution, which has just celebrated its 25th anniversary. I don't think many people thought when it was adopted that it was going to get to 25 years, but here it is. Again, it is a good way to approach how to understand the multiple theories of how Russia approaches law today. It contains notions of division of powers. It contains notions of federalism, advanced notions on rights. But what I argue in my book is that the most important section is the notion of the state and state power, because there are several provisions in the law that emphasize the supremacy of state power. And it is, of course, the president who, first and foremost, represents and has and exercises state power. And it explains how the 1993 Constitution has been used to promote the centralization of power under Putin.
What does that tell us about that document, that it has been able to endure, and maybe not just endure, but arguably flourish when you look at the prominence of the Russian Constitutional Court and the references to the Constitution that proliferate under such radically different versions of the Russian state, the weak, scattered state of the 90s, the consolidated vertical state under Putin, and whatever comes next.
Right. So Putin has said from the very beginning that he's satisfied with the current Constitution. And he has in certain cases abided by the Constitution. He has in certain cases let certain institutions evolve. The one example that you raise is an important one, the Constitutional Court. But he has also used the ambiguous language in the Constitution, as I said, to centralize power. So the best example that I often cite is Article 10 of the Constitution, which is the theoretical division of powers, which begins with the notion that state power is divided between executive, legislative, and judicial branches, and that each branch should be autonomous. So scholars naturally look to the second half of that provision and say, well, here's a beginning of division of powers. And indeed, during the Yeltsin regime, one can find a division of powers. But in fact, the most important term in that clause is not the division of powers, it's what it begins with. And it begins with the notion of state power. And again, state power is always unified. There are several provisions in the Constitution that emphasize the single system of executive power, of the unified system of state power, of the importance of state integrity. And Putin has been able to use these provisions, these terms, to promote a return to the power vertical and to, again, emphasize the power of the president. The president is in fact not even a part of the division of powers because the president is not part of the executive branch. The executive branch under the Russian Constitution is the government. And so this provision that talks about divisions of power doesn't include the president. And yet Article 11, the first state institution that is authorized to exercise state power, is the president. And so this language has allowed Putin in a very flexible manner to accumulate power. There are other provisions in the Constitution that have also contributed to Putin's the centralization of power. For example, the right of the president to exercise legislative initiative, not to have to go through the parliament, but to actually be able to propose his own legislation. The fact that the procracy is still mentioned in the Constitution and its position has been buttressed when Putin reformed the Constitution in 2015. All these provisions have allowed Putin to strengthen the presidency and has relied on it. One caveat, of course, is that for 4 years, Vladimir Putin wasn't president. Dmitry Medvedev was president. And I think what that 4-year interregnum showed is that while people like to emphasize the notion of the super presidential system within the Russian Constitution, again, it is the state that is the most important authority. And even while Putin was prime minister, he never lost control of the state, whether it be the media, the security services, the procracy, and so forth. And so as we contemplate what lies ahead maybe in 5 years, as Putin's second consecutive term comes to an end, one assumes if he does want to stay in power, and in fact no longer, and doesn't change the Constitution so that he can have a third term as president, then he will have to identify ways by which he is able to retain control of the state, but not necessarily remaining president.
Well, you kind of teed me up for that one, Will. Maybe my last question before we throw it to the audience then will be about directions for potential constitutional and significant legal reform if, in fact, we have a continuity of Putin or the Putin system. What's that going to look like 10 years from today?
So obviously it is
not
open to speculation.
in the book.
Not in the book. But I do I do try to end. How does Russia change? If indeed Russia wants to change from its present system of law to a more of a law-based state, or to the notions of rule of law, and what I argue is that what Russia has to address, and what Russia has never addressed completely, is how to get from notions of zakonos, of legality, to notions of rule of law. Because if you listen to Putin, but if you listen to Tsarist ministers and Soviet leaders, they all talk about the notion of legality. And the notion of legality is not the same thing as the rule of law or the law-based state. The notion of legality essentially focuses on notions of fulfilling the law, of both government agencies and citizens to fulfill and observe the law. But it doesn't bind the state. Putin on many occasions talks about the supremacy of laws, of statutes, but he doesn't ever talk about notions of rule of law, of правовое государство. And so the question is, how can Russia get from notions of legality, zakonos, to notions of the rule of law? And as best I can determine, they can only do so by repeating the 1990s, as it were. They have to somehow ask themselves, if they want legality, how do you decentralize? How do you create private reservoirs of wealth? How do you restrain the state power? These are all questions that are left unanswered from the Yeltsin transition. All questions that Putin has kind of used traditional statist principles to resolve for the time being, and has served him well for the last almost 20 years. But if Russia wants to change its legal system, it has to move beyond notions of legality, and that has always been a critical stumbling block.
Well, the new Russia, as of January 1992, left many questions unanswered, but we will do our best not to leave questions unanswered in this room. So if you raise your hand and keep it high, there are 2 microphones on either side, and I'll recognize you. If you could just give your name and affiliation and a question that ends in a question mark, then I think we'll have the best shot of getting through a great many of them. So I saw Anders first, so I'll go first to Anders.
Thank you, Matt, and congratulations upon the book. We'll have read substantial parts of it, and it's very readable to a non-lawyer because it really shows what does law mean in Russia. And I think you answered that question very well. You put it that there have been 2 periods of liberalization in the law. You mentioned the 1990s now, and you mentioned 1906 to 1917 repeatedly in the book. And this led to collapse. So if you could elaborate on the answer you gave to Matt's question right now, what went wrong from a legal point of view? How could Russia develop? My sense is that Russia really needs to learn Montesquieu. Which are the fundamental ideas that Russia needs to learn in order to get it right?
So both
small question.
So both the period of kind of 1906, 1917, and the Yeltsin period. What's interesting about both those periods is because they are accompanied with great moments of optimism. And what's in terms of legal policy and legal procedure, they share something very much in common. And that is having assumed power, at least for the provisional government. What they say is we're not going to pass any laws until the Constituent Assembly. We're only going to rule by decree. And that's what they do. And so there actually are no kind of laws. They're only decrees. And when Yeltsin takes power, he also finds it necessary not to pass laws initially, but also to rule by decree. So the legislature is taken out of the process. So if you kind of want to identify what goes wrong in both of those periods, is that very quickly, both the provisional government and Yeltsin realize that everything is collapsing around them. And the only institution that they have that's viable is the state. And they both call for the return to state power to manage the mess that is producing. So there's this kind of immediate return. Even when the liberals come to power, they often rely on old Tsarist or old Soviet statist legal principles in order to stay in power. And that immediately undermines their ability and their standing within Russian society as a whole. The other thing that leads to collapse is when you have these dramatic moments of state collapse, it immediately opens up the nationality question. And again, both in 1917 and under Yeltsin, you have to try to find a way to keep this empire together. In 1917, it immediately begins to fall apart. they demand, some former parts of the Russian Empire are already outside. But even Ukraine in 1917 begins to assert its autonomy, and the provisional government doesn't know really what to do about that. The same occurs in 1991-93. And what Yeltsin does is he signs all these agreements, bilateral agreements, that are unequal, that undermine notions of unity, that make it very difficult for Yeltsin to do what is an essential part of Russian legality, and that is to deliver orders from the center to the regions. And so again, Putin comes to power, within days, the first thing he does is we have to restore the power vertical. We have to restore the traditional notions of how the state is ruled. So what goes wrong? That the actors adopt the attitudes of their predecessors too quickly, and the nationality question overwhelms the empire in both cases, and they don't know what to do.
Okay, we'll go right there, and don't worry, we'll get around the room.
Louise Shelley, George Mason University. I notice in your index that you pay a lot of attention to corruption, but you didn't do so in your oral remarks. Why do you think that the administration of law in Russia is and has been so deeply corrupted in its administration? Thank you.
I would emphasize a whole, again, that's a whole book that Louise has written already, so I don't have time really to go over everything. Corruption, I think, in Tsarist periods is a reflection of a weak state, that it isn't able to really control developments on the ground, and therefore doesn't have the manpower in which to govern without corruption. In the Soviet period, there's simply no oversight for anybody. And again, so you have these tightly kind of vertical linkages that if you satisfy the demands of the center, then you have tremendous flexibility in the regions in terms of corruption. As of today, again, I think corruption today, and you've argued as to why it persists so much. But one of the reasons why it persists today is that it doesn't challenge the state. It's not perceived as a political rival in many ways. And therefore, Putin, although he makes speeches where he always talks about corruption and the problem of corruption. And if you listen to the prosecutor's office, they'll regale you with all the number of people they brought to jail and convicted who are corrupt. But Putin's system requires corruption to kind of grease the wheels, and therefore it just doesn't go away. And it's been a central part of Russian governance since the beginning.
Can I just abuse my prerogative for a moment to ask you, does the system also require, and has it not always required, the demonstration of generous or kind of noble intervention from the very top in order to right injustices created by the laws?
Yes, there's always been ways to appeal either to the Tsar or to ministers or to the procracy.
Call Putin by FaceTime.
Nowadays you get to call him on question time, exactly right. It's a modern version. But there are all ways to try to circumvent the courts and appeal directly to the head of state or to the major.
Going all the way back to the first code.
Yes, yes.
Okay, I see Wayne. We'll come to you, Catherine.
Mm-hmm. Okay. Wayne Mary, the American Foreign Policy Council. As someone who is a co-author with Will on a previous volume, I'm going to ask him to address two issues. The first, in your presentation, I haven't read the book yet, one could take it that you were presenting the rule of law as kind of normative in the world, and Russian approaches to the state as an exception to that. Whereas I would argue that in the last few thousand years, anywhere in Eurasia, exactly the opposite was the true. That Russian notions of державность would have been extraordinarily familiar in many, 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 many societies, and rule of law as we think of it, and hopefully sometimes even practice it, would have been very much exceptional. That indeed you're finding return of these notions of the state in a number of societies, like Turkey, like Hungary, others we could name, and that in a sense, while Russia's Darozhavnost is unfortunate and going in the wrong direction, it is not a deviation from a social or historical norm. And rule of law is an aspiration which certainly is very much alive in many Russians I know, but they see it still as very aspirational. And the second, and I think almost anybody who's lived in Russia has always been aware that the Russians think of the law and the institutions of the law not just in terms of their rigor, but in their utter capriciousness of application. And one of the things that's always mitigated the rigor of Russian law, not usually enough, but often, is that it's so unpredictable and utterly capricious, not even just at the level of the czar, but at all levels. And so that Russians' contempt for the law and the institution of the law is not just because they see the law as oppressive, but because they see the law as capricious. And I haven't seen that has changed.
Okay, so the revenge of history and
Yes,
the
okay.
capriciousness of law.
I stay away from the notion of the rule of law for virtually the whole book. I've just kind of mentioned it here at the end because that's the attempt to kind of address the transition. But I don't see Russia pursuing the rule of law, and I don't see Russia as an exception. What Russia pursues is its own notion of legality. And that is a defined term. It is defined in virtually every book on state and the history of, on the theory of state and law. And that is what they strive for. And that's the language that Putin uses. So I don't disagree with you in terms of Russia's aspirations to rule of law. That's not what Putin is pursuing, and he's never said that that's what he's pursuing.
He's talking about other Russians, not Putin.
Other Russians have at times challenged notions of rule of law. So in the book I talk about my beloved advocates, who I spent far too much time studying in graduate school, but they do have a notion of rule of law. And yet what you see is how their notion of law and legality is different from what the state's version, because they're one of the few institutions that puts forward notions of property rights and civil rights. And the state doesn't do that, and the intelligentsia doesn't do that as well. So you have pockets of people pursuing the rule of law, challenging the state. You can argue to a certain extent the dissidents did as well in the 1960s and 70s. But the Russian state is not actively engaged in pursuing the rule of law. It is engaged in making sure that people fulfill the law and follow the law as written without binding the state. So I think that is a consistency in Russian law, and I don't ascribe rule of law tendencies or aspirations to Russia. Yes, Russian law is capricious. There are plenty of examples, again, throughout Russian history.
Your own personal one included?
Yes, it all has its elements of uncertainty, but yes, it is the flexibility and the capriciousness of Russian law that, to a certain extent, gives its power to enforce civic order, because no one knows how the law, in certain cases, will be interpreted, and we've seen plenty of examples of that in the Putin period.
Catherine.
Hi, Will. Oh, I'm Catherine Schuler, and I'm a fellow here and affiliated with the Canon and a professor at the University of Maryland. My question is about imperial law. I worked in those, they were called, at least as I experienced them at the University of Helsinki, they were the collected laws of the Russian Empire, but I assume that's the digest, right?
No, that's not. Those are two different things.
Oh, okay. Well,
Yes.
Then maybe you can explain the difference, but I was going to ask you something. So I was using this as primary evidence for the ways that the state interacted with the imperial theaters. But I never felt that, well, I guess it's a question about evidence. Can you use them as primary evidence of actual practice? because I always felt that I had to be skeptical about them for just the reason that our last questioner said is the capriciousness of the law. So I'm wondering, for you as an historian, and as me as a historian, how do you use the law as primary evidence, or can you in Russia?
Well, you can use the law to identify how the law on paper, and then you have to figure out the law in practice. And those are two very different things in Russia. And those are that's why just reading the law and reading the legislation will not get you the answer of how the law works in practice.
That's what footnotes are for.
Exactly, and this is true of the Tsarist period, and it's true throughout Russian history.
The wonderful thing I remember, certainly true in the Soviet period as well, I remember from working in the party archives, and in particular in the famous Особая Papka Khrushcheva, was that, thank goodness they were also obsessive bureaucrats and kept meticulous notes, including statistics about the way things were being implemented, because that's how you knew what was actually happening and wasn't happening. Okay, I saw another hint, Natalie here, and I thought I saw another. Okay.
Natalie Belsky, also a fellow at the Kennan. Thank you very much, Will. Very excited about your book. Also on the point of imperial law, as you mentioned, like Russia's living for centuries with this rather outdated law code and passing various other decrees. I imagine, though, I don't work on the imperial period, that some of them are contradictory.
Yes.
And there's this kind of bloated system of an old law code and contradictory laws. Do they at all, how do they deal with this notion of contradictory laws? And do you think that has a broader impact on the meaning and use of law?
Yes, it does, because it's always difficult to find out what the law is. And when you try to work your way through all these decrees, some of which are published, some of which are not published, some of which are secret and can never be published, it's very difficult to determine what the law actually is. And that is a problem in the Tsarist period, and it's especially a problem in the Soviet period as well. That I remember in the early 1990s when I met with an environmental group, and they proudly showed me the full collection of environmental laws. And it was literally like a scrapbook, and they had cut and paste articles from his, the laws from his Vesti and so forth, and glued them together. And that was the compilation of laws as best existed on that subject. So the power of decree, again, which is something that unites Russian law from Peter the Great onwards, shows the personal power of the autocrat and of the bureaucracy, but is never systematically organized, and therefore serves as a drag on Russian law, and means that the codes that all look so nice in theory don't really reflect the everyday practice of law as well.
Okay, I saw. Yeah, let's go to Andre first in the back there, and then. Okay, thank you. When you've raised your hands, don't then drop them later because I don't necessarily see them. Go ahead.
Andrei Larian of Cato Institute. Let's imagine that in the audience somebody from Kremlin, opponent of you, rather enlightened and advanced, and he would.
That sounds ominous.
Just okay. Let's try to imagine. Even it's rather hard, but nevertheless, okay. And that person might agree with your distinction between legality and rule of law. These kind of two basic traditions, some kind of rather contradictory in the Russian history. But that person might say that, okay, yes, it's true, but each time when Russian society is making steps towards rule of law, it comes to collapse, to times of troubles, either in the beginning of 17th century or beginning of the 20th century or the end of the 20th century. And just the problem is that just the source of any law would be legality, not rule of law, because rule of law destroys not only the state, but society, and leads to the millions of victims. So that is why we are forced to rely on legality versus rule of law, because we are some kind of trying to preserve human beings in these difficult times. What kind of arguments you would produce in this debate? Why you think rule of law would be more valuable for the Russian society, even if your opponents would say it would lead to destruction of everything from the state to the order and to the lives of millions.
Well, that's the argument that is usually put up against dramatic legal reform, and I understand it, and there's an element of truth in it. If indeed, if indeed you lose the central power, if you lose the ability to have a power vertical, what holds the empire or the nation together? And so that makes any transition to rule of law very difficult. One can argue, if you look at the Yeltsin reforms, and obviously there are people with strong views on both sides, that for all its faults, it at least found a way to introduce private property, to try to have a legislature that is asserted some independence, and would have allowed potentially for innovation and reform. But it is a troubling question. If indeed the goal is to hold this vast continent together, can it be held together by granting independence and local self-government, as it were, throughout the space? Obviously, someone like Solzhenitsyn believed that if you had local self-government that was truly independent and reflected local interests, then that was a potential building block to change. One can argue that, and that's why he was had such a favorable impression of the Zemstvos and so forth. But it is a difficult path, as we've learned every time Russia has tried to take that path, because it does potentially lead to collapse and an inability to hold the country together. And so you have to ask yourself, if you want to try to make Russia a more competitive nation, a more modern nation, if you want to actually have true pockets of civil society, what sort of other challenges does that place in a multinational, multi-ethnic state? The advantage of relying on the state is that non-Russian nationalities can still be vested in the state and still find ways to keep a stable government. But if you look throughout Russian history, when they ask them what the purpose of holding the state together, it's not overly ideological. Invariably, the answer is to preserve the state and to maintain the status quo. We had a talk here with Masha Littman just 2 days ago, where she emphasized that the Russian state today is non-ideological, but focused on maintaining the status quo. And so, if that is the greatest aspiration, to kind of keep everything in place as it is, then that is obviously a detriment and a potential obstacle to any broader notion of rule of law.
Okay, we have less than 3 minutes and 4 questions standing between you and our reception. And so I will take a very American approach and try to balance between zakonnost and prava and say that we will take all 4 questions and Dr. Pomeranz will do his very best to answer them in 5 minutes. Is that fair? Okay, so we'll start right there with the gentleman. Yep, very good. And then here and the 2 of you.
Thank you very much. I'll try to be quick. Rob Hollister from Department of State. You mentioned that after the elimination of serfdom in 1864, that the peasantry was not governed by law, but rather by custom. And Alyona Ledenova and others have written about, the pervasiveness of informal practices in Russia. What's the impact today of that reality in the 1860s, that law didn't reach down to the level of peasantry and customs continued? And secondly, can you clarify any of the confusion around the recent headlines that bribery has now been legalized in Russia? There are articles both ways on that it has and it hasn't. Thank you very much.
Right here.
Sofia Balashvili. I'm an exchange student from Russia. I study at American University. So I'd like to ask, so in order for a legal system to evolve and to become more liberalized, more people-oriented, we not only have to change like the top, the legislators, but also to make some changes in legal awareness of people. So the reason why system is so authoritarian in Russia, I guess, because the president and the government have this authority to like change the law because people do not oppose. And the vast majority of people in Russia have really specific approach to the legal system. So they just follow the rules. They never have like any initiatives or something like this. So what ways would you suggest for legal system in Russia to change? Because I think it's not only about the legislatures, but also about the people. Like, what should they do in order to change the legal system?
And then right here and here.
Hi, my name is Jasmine Cameron. I work for Justice International, and we work with Russian lawyers, practicing advocates. My question is that I'm curious to hear about role of lawyers in Russia, specifically if it's possible under this system, as you call it, sort of the system of nadzor, where the lawyers have a sort of very neutral observer status, to more proactive role of advocates. Thank you.
And last question. Yeah.
I'm Natalia Rostova, former Canon Institute fellow. I have a question about the Constitution. How much does it challenges Putin's power now? How much is it facade? Can he rule further without changing Constitution? What do you think?
Okay. All right. There's a wide range of questions.
Yeah.
Good luck.
Thank you very much. We'll start with custom and the impact of custom. Custom it had an important impact in the Tsar system, because it meant that approximately 80% of the population was not immediately subject to the reformed courts, and so they continue to be governed, at least in terms of civil law and local transactions, by custom. And yet, so it has been criticized for the fact that it excluded such a large percentage of the population from the court system. But recent research, I think, has shown that indeed peasants were very litigious, and there were plenty of peasants who decided if they lost in the customs under customary law, that they would go off and try to pursue litigation in the regular courts. And the research of Jane Burbank has shown that, in fact, it was despite its limitations, it still was an important school whereby peasants learned to assert their rights in court. It wasn't based necessarily on the statutes, but it was said it was based on custom, but it was perceived as having an impact in terms of the broader expansion of private law and civil law. Eventually, under the Soviet Union, in the Soviet period, they got rid of customary law. So customary law continued to exist up until really Stalin's decisions to collectivize the peasantry. And then he abolished custom, and all Soviet citizens then fell under the respective civil codes of where they lived. That's not to say that custom wasn't a source of law in the Soviet period. It was a source of law. Clearly in the Caucasus, custom played an informal role in terms of how people interacted. And so the informal networks persisted, and Lineva emphasizes that in the Soviet period, where she focuses on blot and exchange of favors. But most of the informal practices in terms of exchange of favors ended with the introduction of a genuine system of private law, contracts, and money. In terms of the whole question about bribery and this whole debate that's taken place about is certain principles of certain acts of bribery possible, My understanding that at least that law was perceived as a very narrow application of allowing exceptions to the bribery statutes, so that, for example, if you, I think the example that was used, if you were getting divorced and your wife wasn't willing to declare her income, that wouldn't be taken into account in determining whether an act of bribery or not. So it's unclear even in the Russian press as to what its implications will mean. But my understanding is that it is applied very narrowly. The next question was on
Popular initiative.
Popular initiatives and what can be done. Again, one shouldn't underestimate, despite the difficulties of the Russian legal system, of people exercising their rights under Russian law. What's interesting is that they're less prone to defend their political rights and more willing to defend their social rights. And so that if you want to see a kind of engaged citizenry in action, it is an active defense of their right to pensions, housing, medical care, and so forth. And that's where people are engaged in. And and that's where a lot of legal aid provided both by the state and by the bar associations is directed to. One of the interesting things when Medvedev became president is he talked about the problem of legal nihilism. The interesting thing is that he blamed the people for legal nihilism, and he never actually took into account what the state's role in it was.
They never learned the right political answers, always blamed the lawyers.
There you go. As in terms of the role of lawyers and the role of lawyers and how
their role can change. Is it possible for their role to change?
It is possible for their role to change. Again, there is a major reform ongoing right now that would expand the advocature, the legal profession, that would force all legal practitioners to join the bar. There's opposition to that because these non-advocate practicing lawyers don't want to be subject to legal ethics and other fees and so forth and state exams. But that would be a way by which to enhance the role of the bar and have them become more active. In terms of changing the role of the procracy, that's probably more difficult. The procracy is always seeking to expand its supervisory authority and consistently does so. And I guess the final thing about the role of lawyers is to emphasize is that Russia really doesn't have one legal profession like the Bar Association in the United States, that there are certain sectors of practitioners, prosecutors, judges, and advocates. They're separate career paths, and it's very difficult to unify them under one legal association. And that inhibits the role of lawyers because each branch of the legal profession is defending its core interests.
2024.
2024, constitutional change. I think we're just beginning to try to understand what Putin's objectives might be. There have been various plans floated about. One, they could try to change the Constitution and extend his term. He's been very reluctant to do so. To rewrite parts of the Constitution requires calling a constitutional convention, assembly. Again, Putin apparently hasn't shown any interest in wanting to rewrite it. But we'll have to wait and see what his expectations are leading up to 2024. There are other avenues that can be pursued as well. The union between Russia and Belarus is now being talked about much more. The fact that Russia is sticking it to Belarus in terms of gas subsidies and so forth suggests that a more unified Belarusian-Russian state could provide a platform that would allow Putin to continue to rule without, and then simply kind of downgrading the position of president within the Russian constitution. There's also the possibility that they could create an alternative security council or public chamber or something like that that Putin would be in charge of again, outside the strict constitutional provisions. But again, as I said, as we learned from 2008 to 2012, Putin doesn't necessarily have to be president to control the levers of power and to remain the crucial leader of the Russian Federation. Well,
that is a fitting place to end, and we do indeed have to end. Imagine if something that was promised for a certain amount of time went on forever. A reminder that we're going to have books for sale out in the corridor and a reception also starting right now, so please buy your books quickly and then come join us for a toast. But let's now thank Will Pomeranz for a masterful presentation.
Thank you, Matt.